Welcome back into Eye on Agriculture. I'm Britton Rucker. We are taking a look at a major regulatory shift that could directly impact farmers, ranchers, and landowners. The EPA and Army Corps have unveiled a new, narrower definition of waters of the United States. We're joined now with Roger McEowen, Professor of Agricultural Law and Taxation at Washburn University, to help break this down. Now, Roger, for producers who followed this debate for years, what's the biggest takeaway from this new proposal?
Well, good to be with you, Britton. I think for the first time in decades, it looks like we actually have some conformity with a Supreme Court opinion that gave us what I would say would be definitional clarity on what a WOTUS actually means. And that's good news for landowners, and particularly farmers and ranchers.
Now, how does this rule change which waters on the farm actually fall under federal authority?
Well, it limits federal jurisdiction to tributaries that connect to navigable waters, either directly or through features that have consistent and predictable flows. That, I think, is the biggest development here. Basically, there has to be a continuous service connection, and it must be a tributary. So, in other words, federal control is limited to wetlands to only those areas that are physically touching what would be called jurisdictional waters, and then maintaining surface water long enough to be indistinguishable from those waters.
Now, Roger, the agencies say that this actually strengthens state authority. What does that shift mean for producers?
Well, it does. The shift in federal policy here, often referred to as what lawyers call cooperative federalism. That means that regulatory authority over newly acquired or newly non-jurisdictional waters is basically transferred from the federal government, the EPA and the Corps of Engineers, to the individual states. And we've seen that in other areas of the law. Of course, the Dobbs decision, the abortion decision a number of years ago, didn't eliminate abortion, it just kicked it back to the states, and the states can decide. And Kansas, for example, has addressed that, as a number of states have. So greater state rights here under cooperative federalism. And for producers, that shift, I think, has two major contrasting implications. You have a reduced federal burden, and then the rise of state-level regulatory patchwork, which from a political standpoint, that's probably the way to go, because water issues are different depending on what part of the country you're in. So it makes sense to have the states regulate this. And then if there are issues that come up, it's easier for farmers and ranchers and others to address their local elected representatives at the state level than it is to deal with a massive federal bureaucracy. So that's really what the change is in terms of strengthening states' authorities.
And final question here before we wrap up. What's the timeline, and how can farmers and ranchers weigh in during the public comment period?
Well, the rule was published November 20th, and it was published in the Federal Register, which kicks in the start of the comment period, and that began. And so that's a 45-day period. So the deadline for all your written comments to be submitted looks to me to be January 5 of 2026. And then after the agencies review all the public comments, they'll draft and issue the final rule. I would expect that to be by mid-2026. And the effective date of that will probably vary. Typically, a final rule takes effect 30 to 60 days after its publication. So we're looking perhaps August, September of next year. But again, there could be legal challenges that delay or alter the application in certain states. And we've certainly seen that over the years with respect to WOTUS. But that's how I see the timeline right now.
All right, we'll keep an eye on it. Roger, thanks so much for coming on the program. We appreciate it.
Thank you for having me.